Hi, I'm Jennifer Kupiszewski of the Kile and Kupiszewski law firm. My partner Emily Kile and I practice here in Scottsdale, and we do a lot of adult guardianships. In my prior life, before I was a probate attorney, I was a family law attorney, and so I have a lot of understanding of the intersection of family law and probate law. So I end up talking with a lot of parents who are divorced or separated, whose disabled child is turning 18 and they need to seek a guardianship. And what does that mean and what does that look like for them? So Cynthia's asked me here today to give my top 10 asked questions on divorce and adult guardianship. So number 1, I've heard you can file for guardianship 6 months before the child turns 18, and I want to be the parent appointed as my child's guardian. Does it help my case if I file first? No. We wish it was that simple, but it's not a first in time filing question. If the one parent files and then the other parent files, it will just be considered a counter petition or a cross petition. And so it doesn't really help to be first. There's no point being in the courthouse on the day of that you're able to file and being there at 8 o'clock and filing first. The court will just look at it and will take if there's two competing numbers for probate numbers that are assigned because two competing guardianships were filed, they just take the first one that's filed, use that number, and consolidate the other one underneath. So it doesn't really change anything. Don't get up early for it. So the second question I get a lot. We have a family court order for parenting time and decision making. And what happens to that when the child turns 18? Well, you can't have a parenting time order or a custody order or a legal decision-making order over a legal adult. So it ends. That's what that means. Yeah, Cynthia's going, wow. Yeah, all that work you did and it ends. It does impact the guardianship, but it is no longer an enforceable order. You can't go back to family court and enforce your parenting time order when the person is 15 minutes late. So number 3, I've heard that parents have priority for being appointed as guardian. So what does that mean? Well, each parent stands in equal priority, and it means that you have competing priorities. And it means that initially both parents may be in the same position, and the court will need to make a decision. Should they be co-guardians? Should there just be one guardian because there's issues with one of the parents? And so the court has to look to the priorities and to make a determination as to what is in the alleged incapacitated person, that is the person who is going to be under guardianship, what is in their best interest. The court will look to those prior family court orders to see what was going on and what that prior family court judge decided when considering the parent's priorities, which is why, and here's a tip, you have to attach the last parenting time and decision-making order to your guardianship petition. You must tell the probate judge what happened in the underlying family law matter, if there is one.
And when you're doing guardianship, doesn't the court give the child a lawyer to represent them?
They do, but now you're goofing up my 10 asked questions.
Oh, I'm sorry.
But I'm going to answer your question anyway. Now we're going to have 11 asked questions.
Okay.
Yes, so a guardianship is a taking of an individual's constitutional rights. When we turn 18, we have the right to be responsible for our own decisions. That's what it means. And you're going into court and you're saying, it's not safe for that person. They don't have the capacity. They have an underlying medical condition that prohibits them from making reasonable decisions for themselves. Well, you can't just say that. They have a right to defend and to give their position and to not have their constitutional rights taken away. And so they will be appointed a lawyer in Arizona to represent that position. So I am often asked if you have to tell the other parent that you have filed for guardianship, because wouldn't it be great if you could just go down and file and get appointed and not tell anybody, because then you don't have to fight about it. Well, a guardianship is a legal action, just like any other legal action. And so you have to notice all of the proper parties, which means that you have to give service to the person who's going to be under guardianship. And in Arizona, it is required that you also personally serve the other parent. So yes, you have to tell them and you have to give them the documents that you filed. I would recommend, if at all possible, that you talk about it ahead of time. So What if a parent has sole legal decision making, sometimes referred to as sole custody? Does that change the priority? Does that change the equal priority of the two parents? And the answer is yes. That means that in the underlying family law matter, that the family law judge has found that one of the parents was either absent or not fit to make legal decisions. So that creates a presumption for the probate judge in evaluating who should be appointed as guardian and the priorities of the two parents. If one parent wasn't fit or was absent such that they couldn't make decisions when the child was a minor, it's highly likely they will not be presumed to be able to make those decisions for the child who needs a guardian as a guardian. So what if both parents had joint custody or joint legal decision making, and maybe equal parenting time or maybe not equal parenting time, but we're sharing that decision making? Can there be co-guardians? And the answer to that is yes. As parents can be co-guardians over their child, who's now 18, who's actually an adult, considered the protected person. So there can be co-guardianship, and again, if there was joint legal decision making, that creates a kind of presumption with the probate judge that they should be considering co-guardianship if the two parents can get along well enough. So if you are co-guardians, does that mean you have to go to every doctor's appointment together, or do you have to go to all of the meetings that the child may have with the school or with the Division of Developmental Disabilities? Because that might be a lot of together time for parents who are no longer together. And the answer is no. The guardianship orders typically read that co-guardians can act independently, so that while the child was maybe residing with one parent who's also the co-guardian, they could take them to the doctor and just inform the other guardian. They would have to keep them informed, but they don't necessarily need them there for routine decisions. So the law says that a guardian is like a parent to a child. So I get asked a lot, so what changed? My child was 17 and 364 days, and then I woke up the next morning and they were 18 and they were an adult, and everything looked exactly the same to me. So what changed? Well, what changed is your legal responsibility. You're no longer legally responsible for that minor child, because it's not a minor child. The child is actually an adult and responsible for themselves. And so, as opposed to you presumptively from birth being responsible for that child, when someone applies for guardianship, they're going to the court and saying, I want to be under your jurisdiction, court, and I want you to appoint me and give me back those responsibilities that I had previously, because I want to continue to be responsible and to make decisions for this child who's turned 18, because they can't do so for themselves. So it is legally a big shift, even though on a day-to-day basis, it looks the same. And finally, what are my obligations as a guardian for visitation with family and the other parent? Well, in Arizona, the guardian does have obligations to maintain those historical relationships if they are in their ward, so they're the incapacitated person's best interest. It means that they need to make the person responsible for access. But a lot of people think, well, that means I still need to arrange pickup and drop off, and I still need to, maintain the way we had it before. And that's not what it means. It means that the person appointed as guardian needs to allow access for the person under guardianship to maintain their relationships and not be obstructive. But it doesn't mean it needs to look the same as when the child was a minor.
And if the other parent doesn't get access, can they go back to the guardianship court and complain?
Yes, they can. So guardians need to be aware of that. Yes, they can. They can go back and do what we call a petition for access, and that's a demand to see the now adult child. And there will be discussions about what's in their best interest and why. There are factors for the court to consider, like history of substance abuse or domestic violence. So there are a lot of things that the court has to consider, but yes, the person can go back. And I just thought of one more question that I really should throw in there, and that is, if I'm the guardian, can I make the decision to move the child who's now an adult out of state? And the answer is yes, but don't forget you have an obligation to ensure access and to consider that as part of what is in the person's best interest. So that is something I would counsel people to think long and hard about and really take all those into consideration. So the answer is yes, you can move, but there may be consequences and things for you to consider.
And just one general question, how long does it take to go through the guardianship process? One, if no one's contesting, and then two, if someone is contesting.
So contesting, just to define that, means that you filed for guardianship and then someone showed up and objected and said, no, I want to be the guardian, or I don't think that person should be the guardian, and here's why. So if it's uncontested, which means everybody agrees, including the person who's subject to the guardianship, because they have a right to say, I don't want to have a guardian, I think I'm fine, and I can make my own decisions. If everybody agrees, it takes 45 to 60 days to make that, to get that determination. If it is contested, that is going to depend on the judge's calendar, discovery, and a lot of factors.
So not short, probably.
Not that short.
Okay.
All right.
Okay, thank you.
You're welcome.